the matter of M, a child.
Yes, Mr. Gupta, can I apologise for the temperature in here? It's absolutely freezing. We did look to see if we might be able to move to another court, but you won't be surprised to hear there are problems with the heating in this building at the moment. But if anyone becomes extremely, genuinely uncomfortable, we'll obviously rise for a few minutes for everyone to go and jump around in the corridor.
Thank you, actually.
Now, Mr. Gupta, can I tell you, we have all read all the papers, including, in particular, the matters in the supplementary bundle and in the core bundle, with, in particular, the various reports, together with all the skeleton arguments and the supplementary submissions that have been made. So you can.
Well, thank you for those words, Your Ladyship. Can I just introduce everyone and say at the outset I was planning to be no more than an hour in my oral submission, subject to any anything the court
as
may
I
have
say,
to
we've read into the case, and
Yes.
and it seems to me that whilst the issues are, of course, extremely important,
Yes,
that it shouldn't necessarily take a huge amount of time.
indeed. We respectfully submit it's a discrete point.
Yes.
And I should say without further ado that I, together with my own Judy Miss Shield, represent the aunt and uncle, that's
Yes.
the maternal aunt and her husband, of course, Mr. Tyler, King's Counsel, and Miss Reed represent the local authority. Mr. Brooks Baker represents the mother, Samab Sheikh represents the father, and Mr. Siles represents the child by way of the guardian, the children's guardian. My client is joined, or my clients are joining by the joining live streaming link.
Have we checked that they can hear?
My solicitor, I think, is in touch.
Good. Well, do let us know
And if there's any issues, we'll let you know.
Please do. Thank you.
And essentially, of course, I represent a lady, together with a husband, who wants to look after her sister's child and be assessed for that purpose. She has 3 children of her own. She lives with her husband in between Islamabad and Lahore, for those who know the geography of Pakistan. And I'd like to highlight a few passages at the outset from the judgment, which you'll find in electronic bundle reference 102. It's one on from the normal bundle reference because of the addition of the index page. So just add 1 or subtract 1.
Well, if we can use paragraph numbers for my purposes,
Certainly.
Mr. Gupta, that would help.
Paragraph 26. I invite the court to just bear in mind that the CFAB assessment that, of course, you've had a look at, which we say is an extensive assessment, more than simply a viability assessment, was the second assessment, because there was an initial stage 1 viability assessment.
Which we haven't got.
Which the court doesn't have.
Well, do we need it if you're going to rely on it?
We don't believe you need it. What we're saying is that the CFAB assessment built on that assessment, and that it wasn't entered into without the court first having.
Well, the court approved it as necessary, so.
Yes, indeed. And so the second assessment, essentially, is the CFAB assessment, with respect to submit. Took some time, obviously, as you can see from that paragraph, and was detailed. More detailed, we would say, than the viability assessment would have been. And the court obviously has had a look at that. I'd ask the court to bear in mind the third assessment that would have taken place, paragraph 77.
Paragraph 77.
77 of the judgment, page 1, 2, 3, electronic closure reference. And this is the reference that we have in our skeleton submissions, that the plan, as latter part of that paragraph, the assessment plan, originally proposed was for a period of 3 weeks. So it was getting the aunt and uncle over, as further
All 3
assessment
children?
with their children, and she was then going to stay with one of her children if the assessment, the final part of the assessment had been completed, introductions had taken place, things were going well, and then my female client was going to stay on with her youngest. What isn't in the bundle, and I can read it out because it's a recital from the order of the 19th of August 2024, it's not in the bundle, It's just one recital which our submission encapsulates the problem. And upon it being recorded that the local authority shall, without delay, provide any letters of support to the aunt and the uncle as required to have the money released from the bank in Pakistan to them to assist them in obtaining the necessary visa to be able to enter the UK.
I think we better have a copy of that order, please.
Yes. It's been circulated this morning, we'll send it through.
We also should have had a copy of the order of the 24th of June and the order of the 1st of August.
Yes.
We should, of course, also have had the Guardian's report and the social worker assessments. But I think we can manage without those, but I would like those orders, please.
Yes, I'm grateful. We'll send those through in one email.
Thank you.
Okay.
That would be...
And that touches on the cumulative nature of the position that we say the learned judge found herself in, which is with there being a gap in the evidence.
Sorry, where's the gap?
The gap being this further assessment that didn't take place in England.
Well, absolutely, I understand
Yes.
that. But as I understand the structure of where we were when we got to the final hearing, is that final hearing was in the context of the father accepting he couldn't look after the baby, but the mother being very anxious still to be considered
Yes.
as a carer,
Yes.
with a care plan for a placement. So the realistic options that the judge was to consider were going to be the mother as a realistic option because everything was complete with her. Your lay clients were not quite properly putting themselves forward as a realistic option. What they were saying was if mother was ruled out as a realistic option, then the court should adjourn the proceedings for a further assessment.
Yes.
So basically their application was if the mother was ruled out for a further assessment. And the case management decision the judge had to be made was whether it's in the best interest of the child for there to be a further assessment of the type.
Yes.
You helpfully described.
Indeed. And using that phrase, paragraph 73 of the judgments. Although the placement with the aunt and uncle is not put forward by the family as a realistic option for the court to consider now, etc.
Yeah, so at week 60, whatever it was,
Yes.
62, your application was for an adjournment for a further assessment.
But of course, I mean, obviously one's not interested in blame game. My
Well,
clients,
I understand the frustrations,
yes,
and I don't underestimate them. But the fact remains that that's where everybody was at week 62 of this baby's life.
indeed. Paragraph 71, just further up on that same page. The court below is very clear to point out my client's commitment, engagement, etc.
Absolutely, and not easy for them to have taken part in the CFAB assessment. And here
yes,
they are online.
They are online.
Coping with this. It's gone on for a long time. They've had to talk to their extended family about this. They've had their life, their home photographed and scrutinised. I don't underestimate for a moment the commitment they've shown to seeing if they could offer a home to him in his best interests.
I'm grateful for those words on my client's behalf. We say respectfully that this is, when I say the phrase realistic option, I don't mean realistic option now, of course, as we've just touched on, but it is something that we respectfully submit the court below should have approached with a can-do mentality at that hearing, which is be robust about directions.
But how could they possibly be robust given all the uncertainties? And I know you don't like the word uncertainty, but you know, just for example, the advice is that an order with all the uncertainties of how much protection an order in Pakistan could actually give under the terms of the Pakistan law,
Yes.
has to be dealt with within 6 months. Well, we've got a statute that says care proceedings have to be dealt with within 26 weeks. And the advice that we've all been given is that such an order should be obtained prior to placement, and that a special guardianship order should be obtained prior to placement. I'm struggling to see your criticism of the judge for being concerned about whether or not you could really look at short timescales, or that it was realistic for the judge to put in really firm dates for everything.
Well, if I can respectfully ask the court to look at paragraph 3 of our skeleton submissions.
Of course.
And this is really a policy point that this court, of course, can say potentially in this appeal, which is we say that unusual cases where international placement of a child in abroad in a country that's far away like Pakistan.
I agree. I absolutely agree. I think my concern is that not in those. My understanding has been, and please correct me and take me to authorities to the contrary, is that the delay, if you like, tends to be after the decision's made because of all the complicated nuts and bolts and, placements and approvals and visas and all the rest of it.
Yes.
It's not that the big delay is not in deciding whether it should happen at all. Here, what I think that one of the concerns for the judge is you've got the big potential delay of even trying to get an assessment off the ground and complete. Then, if the assessment is successful, the further unknown delay of trying to then implement it. I need your help about that.
Well, Your Ladyship, we respectfully submit that it's not necessarily unknown, but also the timescales with regards to how long it could take. 6 to 12 months, for example, is a phrase that was used as it was a pessimistic timescale.
Really? Do you think? Why is it pessimistic when we think that when the child wouldn't be placed until there was an order in Pakistan? It would take up to 6 months. So
yes,
there's the first 6 months.
Could take up to 6 months, yes.
There's your first 6 months.
Yes. Well, one's looking at
and
it
then
from
we've
the
got to get
pessimistic
visas, get them over, do the assessment, come back to court, get a review, get a special guardianship order.
And this is all something the court below was trying to avoid prior to the hearing,
Absolutely.
the final hearing.
Of course they were.
The question is, because it wasn't avoided, despite the judge's best efforts, and there's things start to change in her mind when she's starting to say, well, actually this final hearing has to take place.
Mm-hmm.
One ends up in a situation where what was more than we respectfully submit a viable placement for this child, a strong candidate, if I can put it that way, a very strong candidate for this child, place for this child to live. And I'd ask the court to bear in mind the environment that was being proposed by the support package that was in place with regards to my client and her husband. If I can invite the court to look at electronic page reference 166, that's obviously 165.
Is that the call bundle?
That's in the core bundle, that's the CFAB report.
Yeah. Oh, sorry, right, yes.
And this is just a vignette, just to show the support that my clients have in place. All family members, indeed a grandmother, as well as an aunt of the subject child to this litigation, being ready, willing, and on one occasion interviewed further on in the assessment, ready, willing, and able to provide a wraparound care for a member of their family. And that's something we respectfully submit adds to the fact that this is a strong candidate for care for this child, and the court
Of course, on a day-to-day basis, that's absolutely right and of considerable importance, but a matter of concern to the judge and highlighted by the local authority in their skeleton argument is the absence of a contingency plan. And for my part, I should say a concern also that the uncle, I beg his pardon, maternal uncle,
Yes.
anticipates that the burden of having an extra child in the house, even with financial support, will mean that he has once again to move to Saudi to work. Having already,
Yes. Well,
and that a lack of contingency plan and the idea that this maternal aunt, who obviously did a terrific job for 8 years on her own, it's anticipated that she would once again be in that position, then with 4 children.
we respect it, but that shows how dedicated this uncle and aunt are.
I accept that.
They are willing to quite literally move mountains and continents to ensure.
Well, the father would be going, she would be staying.
Yes, the uncle is, yes, indeed.
Do you accept that we have to look at, as well as the day-to-day support, at the lack of a contingency plan and the fact that the father would be moving away?
Of course, the court has to do that. The English court, and England, Wales, and other courts who are dealing with placement of children abroad, would have to do that. The question that occurs, though, is this contingency plan element wasn't an issue when it was being suggested after the report was received from CFAB, when this further 3-week assessment was going to be put in place. That wasn't an issue that was raised by the local authority rather than
Well, wouldn't that have been part of the assessment? Further, just like the money, that there'd been further, it would have been highlighted as a concern, and there would have been further.
But potentially, but if it had been such a concern, then it's plain from the CFAB report it's there, and one wouldn't have gone any further in our submission. If it was all those issues fell away, the only issue was finances. That seemed to be the only main issue, and that's why.
Are you saying that's the only reason that they were coming across to be assessed? Was about
no,
money?
that wasn't the only reason. But it was only a 3-week assessment. So it was only going to be introductions, assessment of how things are going on the ground, dealing with the nuts and bolts, as the court has just said.
Could you just take me to the assessment, because I haven't got that quite clear in my mind, Mr. Gupta, because when I read it, 3 weeks and then a review, my sort of understanding about how assessments work on the ground is that then there's a review and then a decision as what happens next, which can be needing further assessment, it can be taking it back to court, it can be concluding the assessment.
Yes,
I may have got that wrong. I hadn't realised it was end of.
Our submissions, which are at page 32, 33 electronically, Roman numeral 2, states as follows, and of course I didn't appear in the court below.
Understood.
Shielded behind me, and those other
Yep.
That was our understanding. The position of the local authority until the hearing on the 15th of August was that the assessment of the uncle and aunt and uncle as permitted as permanent carers for the child in Pakistan should be completed. To this end, it was filed an assessment and transition plan.
Yeah.
Clearly set out times over 3 weeks of introductions and assessment in the UK, and of which it anticipated the aunt and uncle would begin to care for the child, increasing period of times. This will be followed by updating assessment and in cross-examination
So
session
the assessment
accepted.
wasn't 3 weeks.
No, going back to the judgment, the learned judge explains, as I said, at paragraph 77, the assessment plan originally proposed for a period of 3 weeks, followed by a review. So maybe it was an initial part of the assessment and introductions, a review hearing, and then further assessments. I cannot say that it was a 3-week assessment. I can say on my part's behalf, it was introductions and, as I said earlier on, a transition is the word that we use in our skeleton submissions, a transition plan.
Thank you.
So the hope and expectation, and this is not the basis of the appeal, but you can see the hope and expectation of the aunts and uncles is this is going to go well. we've already had one good violence assessment, we've had a detailed assessment in CFEB, and now we're being told there is this period of time to come over. It's not going to be for long before we start being introduced. And then, yes, the proceedings will continue. And there will be an assessment not only by the local authority, but by the court as to whether or not this is the best option, if I can put it that way, for this child. And the problem is that the nuts and bolts have not been put in place. Again, one's not interested in the blame game, but with no fault of my clients, that they are missing, this child is missing the opportunity, and we would say a very good opportunity of being placed within the family. Family ties is the phrase that comes up, of course, in the appellate decisions. Severing family ties. I take on board what my then friend said on behalf of the local authority, where they mentioned the just turning to it briefly.
Local authority skeleton.
Local authority scans submissions. Paragraph, page 10 internally, paragraph 25.
Thank you.
No presumption in favour of a family placement. Now, we respectfully submit that on the ground, there may not be a presumption with a capital P, a legal presumption, but on the ground, of course, when one's thinking about family ties, the first people that any local authority would look to in a public law matter is there anyone in the family or close friends, but really the family that can look after this child. And the learned judge, in her judgment, of course, is very clear the advantages, potential advantages of placing this child with culturally appropriate familial placement. Paragraph 72, 71, 72, undoubted advantages placed in the care of uncle and aunt. So again, we respectfully submit this is a very strong contender on the face of it for this child. We don't go as far as saying, of course, there's a right to a biological family life. It's a right to a family life, Article 8, of course. But nowhere does it say a right to a biological family life. But what it does say, of course, is there's a stronger chance, we would say, submit, of the child having, as he grows up, it's obvious, isn't it, that he will feel potentially far more secure if he feels that he's got a biological link with his cousins, with his aunts and uncles, with his grandmother and others, and he's being brought up in that environment. And surely, long-term, emotionally and developmentally, that is something to be factored in to the mix. The court having, and this may not be my best point, but the court having waited so long and it's been going beyond the usual 28-week rule so far, doubled, more than doubled, potentially almost tripled, doesn't mean that it had to bring down the guillotine at that stage. We take on board the fact that there were some, for a better word, uncertainties, but they respectively potentially could have been managed better. And the court, the whole problem of getting my clients over from Pakistan is something that we find quite puzzling in the circumstances. I mean, anecdotally, one has been involved in many cases where people come over to court from other places like Pakistan, it's not an issue. With focused, planned and purposeful delay, with the mother as an option being excluded and the court saying, right, X amount of time, we have to see whether or not Arsenal will come over to have a 3-week assessment and have a review. Whereas that would have been proportionate in the circumstances, and guess what, I'm going to use the other word, necessary in the circumstances. Bearing in mind, this was a real runner, more than that. And the learned judge in the court below, of course, in her judgment, cites absolutely all the correct authorities. She doesn't make any mistake in highlighting what she should be considering. But in dealing with the mother's application to adjourn, dealing with her assessments and everything else, unfortunately, we respectfully submit that one of the phrase, the baby was thrown out with the bathwater. There was a far better option that was there. And by saying, well, there's no more time for this child on that assessment, mothers did now to be excluded. Unfortunately, the other option was excluded as well, for the same reasons, when in fact, it's the third part of an assessment.
Well, it wasn't for the same reasons, because the mother wasn't ruled out because of delay.
No, she wasn't.
And
No,
we
she
have a
wasn't
whole
ruled out
separate
because of
new
delay.
section
It's one
that's
of the
starting at
factors.
page 71, dealing specifically with the aunt and uncle.
Yes.
I mean, I take, of course, what you say is having ruled out the mother, that was wrong to rule out the aunt and uncle as well. I get that, but I'm afraid I struggle to accept that it was for the same reasons.
Well, I was just touching on paragraph 52 of the judgment, page 113, electronic page reference, where she's summarising the social worker's evidence. Ms. Stark has refuted there was a gap at the bottom of the page. Gap in the evidence required further assessment. She remained concerned about the mother's lack of insight into the deficiencies in her parenting, despite the work being done, both within and outside assessments, mother's ability to recognise risks from the father and prioritise the children's needs, which indeed so remained poor. So there was this other application that was there with regards to the mother. Another consideration now, absolutely the learned judge then moved on to my client's application.
That's paragraph 53.
Indeed. And having said that, there is this concern that maybe she did conflate the whole aspect of adjournment as being something that she didn't want to do it for the mother. And then she moves on to the aunt and uncle with the same mindset. This has to finish, this case has to finish, as she identified in those earlier orders, which of course the court doesn't have, but has correctly identified. I haven't seen them, but we've summarised them in our skeleton submissions. But obviously, as we move into August, 1st August, 19th August, 3rd of September, the learned judge is saying this has to end. And so consequently, by the 19th of August, that recital I mentioned earlier on, where there's still no visas for uncle and consultants, that there wouldn't have been enough time anyway for them to come over and to be assessed properly for that final hearing. And that's why I say it's a cumulative effect. The question is, does the phrase "we are where we are" cover the whole issue and just say, well, I'm sorry, I don't know, it's like an analogy.
It's a question of where we are,
where we are.
but where the child is.
Yes, indeed. The child has been in foster care, the same foster placement, since October 2023. He did have, obviously, a very disruptive beginning of his life, but since then, he has been settled in the foster placement. The foster carers are not putting themselves forward
Understood.
as permanent carers. So he's right on the cusp now. Where does he go next? I haven't had any information, updating information about what the plans are of the local authority, how far down the line they are with regards to it.
Well, they won't have done anything. Well, Mr. Tyler will bring us up to date, no doubt. But
Yes.
my experience is they won't have been able to do anything.
Well, and there's the other aspect, which of course we highlighted in our skeleton submissions. That wasn't twin tracked at all. So what does that mean? The reason it wasn't twin tracked, we respect the submitters, because the local authority saw the uncle and aunt as being a very strong contender, as I said. So having gone down that route, it's not as if the learned judge in the court below was choosing the other track, which this child had moved down. In other words, the adoption route had not been investigated in the same way it would have been if the matter had been twin tracked. So time has been lost with regard to the assessment of the uncle and aunt and the other track that wasn't taken up.
But the judge recalls at the end of paragraph 53, where she's summarising the evidence of the social worker, Ms. Darkin, that she, that is Ms. Darkins, had been reassured by the adoptive team that such a placement could be found reasonably quickly.
Yes, I don't know what that means time-wise.
Well, we were told match in 6 weeks and place 6 weeks after. Isn't that what it says in the judgment? Referring to the one adoption report.
That's the note of the evidence which we included in our skeleton, which has since been agreed as accurate between the
Yes,
parties.
I understood it being agreed. Thank you for reminding where I knew I'd read it.
Yes. So it's about 3 months. We respectfully submit that despite what was being said about timelines concerning the uncertainties concerning my clients, that within those 3 months, my clients could have been brought over. At least they could have done that 3-week assessment, and then the court would have been in a position, it could have started the twin tracking, could be in a position to see which way it would go, and that it was worth that attempt. And it still is. Because let's say the timeline starts now. We submit there's every option, every possibility that the aunt and uncle could come over and be assessed. If it's not possible, then the other track has been started. Matching will have continued or have been started. And if the local authority is optimistic outlook with regards to that timeline is well-founded, then the court below would be in a position of going, well, sorry, given an aunt and uncle enough time, this now is going to take place. But the court below wasn't in that position. It was just simply saying, well, let's stop that track now, let's start this other track, which will take probably about 3 months, could take longer. And the court, all we can do is rely on the court's own experience in these matters.
So just help me about this then, Mr. Gupta. Your route then would be that the placement order would be set aside. There'd be a care order, obviously.
Yes.
Oh, well, I shouldn't say obviously. Would you say there should be a care order, or would you want that to be set aside also?
I would respectfully submit, thinking it through, it'd have to be it'd have to be set aside interim care order in place, pending these 2 tracks being.
Well, what are you going to do about a care plan when the local authority is saying it wouldn't be their care plan absent a placement order to pay, assess and pay? So what would we do about that?
Well,
or would you say to be remitted for them to get some judicial encouragement from someone else? I just need to be sure in my mind quite how the structure would work that you're asking the court to.
well, the court would be in a similar situation it was in before the court below, which would be, please complete this first 3-week assessment, bring the aunt and uncle over, and then we'll have a review hearing and see where we are. In the meantime, the track about adoption should start in earnest, so that the court below is then in a position after, say, a month or so of knowing where one is with regards to the strong possibility of aunt and uncle placement being up and running. If they haven't come over during that time, because now it seems the financial issues at least will be, I don't know about over, but at least monies would be sent through properly for the visa, etc. If they haven't followed down that line quickly enough, then the other track carries on and the court makes its final determination about the final care order and placement orders. But in order for the trial to carry on, we would certainly submit that yes, the care order and the placement order would have to be set aside. Interim care order for it to consider those further assessments.
Say with judicial encouragement for them to change their care plan so that they would reinstate the funding.
Yes, judicial encouragement is something that comes to mind if the court looks at page 201. And as the court knows, judicial encouragement happens a lot. quite rightly. And here's an example of it. This is the beginning of the addendum report by the local authority.
Yep.
Paragraph 2 of page 202, electronic page reference, or 201. Court being mindful of the significant delay in supporting maternal family to travel to the UK, complexities around financial and legal matters outlined, etc. Court reference judgment to re-W. In other words, the court, of course, was saying at that stage, well, hang on, please have another look at your care planning. Please have another look at this, uncle and aunt. Is this an option, really? And of course, this report ends up with identifying, we respectfully submit, any new issues that hadn't been identified by the Catholic CFAT report, and ends up being negative, as you'll see from paragraph 7, which you've already read at 209. So that's an example of judicial encouragement. One way, and we respectfully submit it could happen the other way. Where there is a will, there is a way, with respect to this. And the will would be correctly placed because of the, as I say, positive assessments of CFAT.
Mr. Gupta, you say where there's a will, there's a way, but there are examples of things which would need to happen, which are not under the control of the court. So it doesn't matter if the court makes a robust order with a tight timetable. For example, whether or not your clients will get a visa, that's not under the control of the court. And another matter that occurs to me is the need for mirror orders in Pakistan. So I was in a situation where not only is the overall timescale uncertain, but there are uncertainties about whether things that need to happen in order for the ultimate aim to be achieved will happen at all.
In my situation, they can be worked around. Visa, for example, the court, the family division judges on numerous occasions invite the Home Office. Of course, family proceedings can't be used as an immigration device, but there can be recitals put in place. There can be orders disclosed to the Home Office saying, well, these are proceedings that involve this child. These individuals are invited to come over to be assessed. Please expedite any visa application. And anecdotally, those things have worked.
But the judge makes a specific finding about that in paragraph 76.
Sorry, paragraph
76.
76.
So she says they'll need visas. Evidence suggests it will take at least 6 weeks. No guarantee or even likelihood that the applications will be successful. And then she explains why she reached that conclusion.
But in my situation, things haven't been tried, such as judicial encouragement of the Home Office, invitation of the Home Office to expedite a visa, which does happen in cases in the family division anecdotally.
And the
Well, the Home Office do
timescales
take-
for that, for the Home Office then to deal with it?
Well, I'm reaching back into my memory now, but have been involved in stranded spouse cases where women have been stuck abroad, being told they can't get a visa because their marriage is over to the UK national, and their visa has been expedited to come over and to attend proceedings and meet their children.
I understand all
So,
that, but all
yes.
that takes time.
Indeed it does, but it hadn't been tried, and it may well be that...
But also the stranded spouse is in a different position because the stranded spouse, as I understand it, is normally somebody who was in the UK or had a right to be in the UK because she was married to somebody in the UK. They then go back to a different country and then she's left there and she can't get leave to remain because she can't get a visa because it's usually the man has divorced her in the meantime.
And burnt her passport.
Yeah, so that's
they
a,
have
but
to get a
that's
new
totally
passport.
different kind of case, isn't it?
Yes, but the principle still applies when the Home Office are invited to assist quickly, and they do so in certain circumstances. This would be a visiting visa for a limited period of time, with a court and the local authority involved, in other words, arms of the state in England involved. And in my submission, that's something that could have been tried and could still be tried.
But then the judge highlights the problem in the last sentence of paragraph 76, that the local authority are no longer willing to provide the funding, and without that, there's very real doubt as to whether they want to.
Well, in my submission, that goes back to judicial encouragement. The local authority were offering funding. The family, of course, as you've read, weren't able to access it. But suddenly to then withdraw that offer, which they'd made before, bit of judicial encouragement. Please carry on making that offer. Please put that back in place. Some judicial overtures in an order, discreet order to the Home Office. Uncle and aunt come over for a limited period
Does
of
the
time.
court have jurisdiction to order the Home Office to do something?
No, it doesn't. An
Right,
invitation.
Just asking.
Yes, it's an invitation. As I said, it can't be used as an immigration device. But the Home Office does listen to these things if it's put in as part of the application.
The passage that my lady, Lady Justice Laing took you to, Mr. Gupta, at paragraph 76, the evidence suggests that it would take at least 6 weeks and there's no guarantee or even likelihood that the applications... Now, where was that evidence? Was that evidence from the social worker, from the inquiries the social worker had made, or was...
Can I just turn my back for a minute?
That'd be helpful. Thank you, Mr. Shields. Mr. Shields.
I gather in evidence the social worker said 5 weeks, the learned judge said 6 weeks. But with regards to the...
I don't think that makes it a ground of appeal.
No, it doesn't. I'm just relaying evidence on. But with regards to how much inquiry the social worker conducted to try and look into how long that would take to get a visa, I don't know.
That wasn't what I was asking. What I was asking, I think, was the evidence was that there was no guarantee or even likelihood that the applications would be successful. That was the evidence before the judge, which the judge accepted, and I just was
Yes.
wondering what the source evidence was. But if
I think it's a social worker.
thank you.
And we can't see why there's no likelihood.
Well, that's the finding of the court.
That's a finding of the court, indeed, based on the evidence it seems that was before it. But as I said, in going back to...
But I take your point. Your submission is that a letter from the court inviting the Home Office to expedite, well, expedite a
Yes.
visa
with it.
would be judicial encouragement to open the purse strings again would be a proportionate and appropriate thing and in the best interest of this child.
Yes, bearing in mind what's happened in the past, in regards to the local authority's position in the past, the attempt of the court to get this couple over to be assessed, has that boat sailed? In view of the delay, we respectfully submit, not necessarily. No, we disagree with great respect, and this child's future militates towards a further delay, most regrettably, but there'll be one in any event. And touching on bottom of page 5, again, I rely on my learned junior's understanding of the situation. I don't think it's been gainsaid. Roman numeral 11.
Sorry, which document
Sorry,
we
page 34, I beg your pardon.
This is
This is skeleton submissions, sorry.
Where I was in the judgment.
Skeleton submissions of on behalf of the applicants.
Okay, paragraph.
Page 34, 35 electronic page reference, internal page 5,
Yes,
paragraph Roman numeral 11.
Thank you.
Again, after introductions in England, the plan was for progression into direct care. I'm sorry to repeat this point, but that's how far gone it was with regards to the court's thinking, the local authorities' thinking. So if I can just turn very briefly to the authorities, I know the court's fully aware of the authorities, all of them, in this matter, and of course I'd ask the court to bear in mind the first passage, which is the first document, which is section 32(5) of the Children Act, which does allow an extension of the period. That's sub-paragraph 5, electronic page 4 of that manual. A court in which an application under this part is proceeding may extend the period that is for the time being allowed under subsection 1A2 in the case of application, but may do so only if the court considers the extension is necessary to enable the court to resolve the proceedings, and here's the word we like the court to bear in mind, justly. We respectfully submit that for there to be a just outcome, bearing in mind everything I've said before in our submissions, and those indeed on behalf of the parents which we adopt insofar as they're relevant, that a just outcome would be for the orders of the court below to be set aside, and there to be this further attempt at inquiry, and that it's worth it. For the court's notes, we respectfully adopt paragraphs 21 to 29, 32 and 33 of the submissions on behalf of the mother, and paragraphs 11 and 12 of the submissions on behalf of the father. But going back to the authorities, I'd ask the court, we of course highlighted a certain passage from the authorities, but I'd ask the court to bear in mind paragraph 116 of the Supreme Authority Re B, which this court will know full well. I just wanted to highlight this point.
Paragraph.
116, which is of course we respect in this matter more than potentially other matters that have been recorded. The Article 6 and 8 rights of my clients, and indeed of the child, are actually very much so engaged. And it's not simply a decision as to whether the court below was wrong. I'd ask the court to bear in mind what's said there by in the Supreme Court. I think it's Lord Neuberger. 116, touched on again at 130. I beg your pardon, 215. But it's not that the end of the story. We all agree that an order compulsorily severing the ties between a child and parents can only be made if justified and overriding requirement pertaining to child's best interest. In other words, the test is one of necessity. Nothing else will do. Again, necessity, proportionality. Judge referred to proportionality when directing himself. We respect that this court has its own overriding duty as to the human rights of the aunt and uncle and the child. We respect that they're not in conflict, but they all point in the same direction, and in the sense that family ties should not be severed unless there's a high degree of justification, and that's where I look at paragraph 130 of that decision. And goes back to the point that we're simply saying that the guillotine came down too early, which is a bit of a strange thing to say when the matter went on for so many weeks, but it's still just about a high degree of probability that this assessment was going to be successful and should have been continued. The court should have continued the proceedings to allow for that to happen, whilst at the same time, as I said, twin tracking it. And this doesn't fall within the category of, for example, S&L, which is an authority of Law Justice Jackson, tab 9, which is just an example of a recorder, page 196. Of a recorder sitting in the family court and therefore adjourning the matter when it didn't require adjournment, and that actually the decision was wrong. Paragraph 15, end of that judgment, page 201, electronic page reference. An appeal to this court can only see the decision was wrong, or there's been a serious procedural irregularity. In this case, both conditions are met. The decision to adjourn was clearly wrong. The parents had been intensively assessed in relation to one child. There was no gap in the evidence to justify a further assessment. That's the phrase, of course, that was used by the learned judge in the court below with regards to the mother's assessment. We respectfully submit, and we've used that phrase with regards to the lack of that final part of the assessment when it comes to rights. But this is an example of an adjournment being granted wrongly. In our respect solution, this case, the incident case, is an example of an adjournment not being granted wrongly. Going back to our skeleton submissions, and bearing in mind my original time estimate, unless the court has any further questions of it, I'm mentioning this so my learned junior, my instructor list can start thinking if there's anything else they want me to add.
Can I just get back to the passage you relied on in paragraph 130 of Re B?
Yes.
The facts in Re B are rather different from the facts in this case.
Yes.
Is this really a case which that observation applies? Because the family ties in question, the focus of your argument is on the family ties with the maternal aunt and her husband, and that they've never met the child. They've had no contact with him other than remotely. So this isn't a case where a child is being removed from its birth parents or anything like that, is it?
No, it's not.
So,
Indeed,
so is this really an apposite?
It is not on all fours of it. One can say that many of these authorities are different because they talk about parents and children. And that's why I was talking about the Article 8 rights, not talking about the biological family, rights to a biological family.
But the weight that's given to Article 8 rights and proportionality balance must surely vary depending on the nature of the family life in question.
Indeed.
Do you accept that?
I accept that, absolutely.
Thank you.
But that's why I was trying to touch upon earlier on, I mentioned in the CFAB reports about the family setup over there, the grandmother, the aunts, cousins, etc.
I understand all that.
This is all future.
But none of them have ever met the child, as I understand the facts.
This is all future biological
right.
family ties.
Thank you, that's very helpful.
Yes. So, as I said, going back to our skeleton submissions, we've highlighted on the final page the paragraph references in Re B that we'd like to highlight. Added to that, those paragraph references, we add 116 and 121 for the court's consideration.
Where are we?
This is, sorry, I beg your pardon, page,
Yeah, I've
electronic
got
page
your
reference
last
40.
page.
Yes, Top
Ms.
of the
Shields'
page.
skeleton.
Yes,
Okay.
top of the page, re-B,
Yep.
where we highlight certain paragraphs, and simply those, and added to that are 116 and 121.
Oh, fine, thank you.
Just bear with me one moment. Yes. Yes, my instructing solicitor just want to identify the fact that they have their passports.
Oh,
But that's not the issue.
recollect that. The
The
issue
issue
is
is the visa.
getting their visas. Yes,
Can I assist the court any further?
you could just help
Yes.
me with this. You've given very helpful global submissions.
Yes.
Can I just take you for a moment looking, I'm looking at Ms. Shields' skeleton argument. Ground one was the plan fraught with uncertainties, and you that remains your case, I believe. Or have
Yes.
you, or are you now accepting there are uncertainties, but you say they're manageable?
Yes.
Which?
Well, there are unknowns. There are unknowns. Can I use the phrase? But they're known unknowns.
Use
But
whatever
they're
phrase.
they're known unknowns. Was the phrase I was
So
going to use.
there are unknowns, which
Yes.
obviously
They're
create-
identifiable.
Which wait a minute. There
Yes.
are unknowns, which inevitably mean there are uncertainties, but you don't like the word fraud.
We don't like the word fraud.
But it's putting it too high to say fraud.
Yes, indeed. They can be worked around. As I say, they are unknowns that have been identified
Yep.
And can be worked through. Because this is not a straightforward matter, placing a child in Pakistan.
So then if we turn through to page 6, ground 2. Now are you still pursuing ground 2?
Well, with great respect, we just think that the pessimistic outlook is to say, well, when the minute one says 6 to 12 months, one assumes it's going to be 12 months, when actually it
Doesn't
could be
say
close
12
to
months.
6.
He says akin to 6 to 12.
Yes.
I just want to know if you're pursuing that ground of appeal.
I have no instructions to, you have my submissions on that point. I don't have instructions to withdraw those grounds, or any of the grounds. But it's the phrase akin to 6 to 12 months. We respect that the court should be looking at that in a more positive light, in a more optimistic light, rather than saying it's going to be kicked into the long grass and it's going to take ages for this assessment to be completed, etc.
I don't think it's really fair, considering the care this judge gave, to say that she kicked
No, I'm not saying
the long grass. 3. Well, obviously, I see that you firmly still pursue that. And you would say the delay is within timescales against the backdrop of your global submissions.
Yes, well,
Four.
bottom of that page, of Roman numeral 3, again, we highlight this was in large part the case had not been twin tracked.
And so far as the focused and robust timetable is concerned, does your submission remain that could be put in place?
Yes, my submission, there are certain things that the court does not, the family court does not have control over, for example, the Home Office or things in Pakistan, etc. But of course, recitals, respectful invitations, these all happen through court orders, and they work anecdotally. They work with using the Pakistani protocol, for example, in Pakistan. They work with the Home Office in this country in an environment where the courts in England and Wales are given respect, comity, when in fact There's no power there officially.
Thank you, that's most helpful. Anything else? Anything else? No, thank you very much, Mr. Gupta, that's most helpful. Mr. Tyler.
My lady. I wonder if I could begin, please, by making 5 general points. And when I've made those, I'll be guided by the court as to how much assistance I can give in dealing with any of the more particular issues in the case. The first of those 5 points is these. I will be forgiven for saying this at the outset, and I hope by saying it at the outset, I won't have to repeat it every 2 minutes during my submissions. The point is this: 62 weeks. At the point of the final hearing, the proceedings were 62 weeks old, with no sign of permanence being achieved anytime soon, or at any predictable time in the future. Clearly, that statistic on its own is troubling. Unpicking it, it's troubling for a few perhaps obvious reasons. The first, Section 32 of the Children Act, there is a statutory time limit. And of course, it's there for good reason. But in any event, we're told, and we've cited the cases of Lord Justice Jacks and Mr. Justice MacDonald, that any and every decision taken to extend that timetable, that limit, for no more than 8 weeks at a time, must be a genuine and a purposeful decision, not one to be taken lightly. The reason, there's good reason for the statutory time limit to be there, of course. We know from years of experience, frankly, of these courts not always doing it well, that children are significantly adversely affected by delay in making decisions about their permanency. The chances of successfully achieving permanent placement reduce with every week that's wasted in finding that placement and making that decision. And of course, there are the other well-researched, well-evidenced emotional and psychological impacts of those. But if that's the general point, looking at this child, 62 weeks of proceedings, given they were issued at the point of his birth, is 62 weeks of life. And I'm loath to make this point such an experienced bench, but we all know from endless research that the 18 to 20 month period in a child's life is absolutely crucial in terms of attachment development. If placement is delayed beyond that, then we know the consequences aren't just transitory, but potentially lifelong. At the point the judge made the decision, which was the 14th of October, if she was right, and we said she was right, to accept that an adoptive placement could have been achieved within about 12 weeks, then this child would have been placed by now, probably around the beginning of this year. So in good time for that developmental window. And of course, it's not a precise science, nothing changes on the day of the 18-month anniversary, but as a matter of fact, that anniversary will take place a week this coming Saturday. And the fourth point we want to draw from that first point, the 62-week point, is this. It's 62 weeks already. So at the point of the decision, it was 62 weeks by then. And so all else, we say, has to be considered in light of that. When considering the impact of delay, it's further delay on top of 62 weeks. When considering a submission that, well, if we're optimistic about this, it might be only another X weeks or Y months. It's X weeks or Y months on top of 62 weeks. When thinking about deploying phrases which have their place in the right case, such as we must never sacrifice justice on the altar of speed, this case is scarcely one in which there can be said to have been an altar of speed. It was already that old. When considering whether it's right to criticise the judge, as has been just done, for having a, quote, this has to end mindset, this was the judge who had conducted the case throughout and didn't end it for those 62 weeks. And of course, we say that the judge was right to accept the social worker's evidence, which necessarily retrospective at the point of the final hearing was, quote, the time frame for the optimum outcome for this child was months ago. Second general point, if I may, this case has been treated differently from the run-of-the-mill case. Mr. Gupta's referred to his paragraph 3, which is the first substantive paragraph, really, of the skeleton argument, which says this. This is an unusual case where an international placement of the child with his maternal aunt and uncle in Pakistan was being actively contemplated by the court and all professionals. Consequently, it's argued different considerations should have applied when it came to the usual PLO timetable in such public law family cases. The usual PLO timetable was not applied in this case. The timescales, the 26-week guillotine was extended again and again. The judge expressed concerns on multiple occasions about delay, as did the guardian, both rightly, but yet, again and again, further delay was countenanced and allowed. And we say that took place precisely because it was recognised that cases which involve the assessment of foreign placements and then the potential for placement abroad are notoriously difficult and notoriously more time consuming than a standard domestic case. Picking up on my Lady Lydia King's dichotomy earlier in exchanges with Mr. Gupta, the delay inherent in cases involving international assessment and placements can occur both before and after the decision is made about in-principle placement. But of course, in this particular case, it was both. The process of coming to a point where an in-principle decision could be made involved the assessment process, which itself was then dependent on, and this has been rehearsed extensively, but the visas, which aren't necessarily going to be straightforward, a family uprooting itself, etc., the process going well, this child settling, etc. But then after that, all else that had to follow. So it was a case, the hardest of international cases, where both sides of the decision, there would be real difficulties resulting in real delay. The third general point we make is this. There was throughout the first instance proceedings, and there has been throughout the documents in the appeal, significant emphasis, quite rightly, on the importance of family, family ties, heritage, the last of those with reference to country of original heritage, religion, culture, etc. The local authority social worker was at pains to pay tribute to the uncle and aunt, as was the judge, and as has this tribunal through my lady. And as the authority still does, this is a couple who, all the evidence suggests, are clearly very well motivated and who want nothing other than to offer love and a home to a family member. But here we pick up on the point touched on by my lady Lady Justice Laing in exchanges with Mr. Gupta. Not all, quote, family placements are equal or the same. This uncle and aunt are, just that, an uncle and aunt. They're not, obviously, the child's birth parents. This family, none of them, has ever met child M. And as Melody points out, that puts them in a different position to a case in which one's contemplating severing ties with a birth parent, let's say, with whom a child has already lived and to whom a child is already attached. Moreover, of course, there's a family, a potential family tie. Of course, there's the fact of family in this case. But the placements contemplated would have involved a child settling and forming bonds whilst being spoken to and transferring attachments and linguistic development with reference to a completely different language. The home conditions which are contemplated as possibly coming at the end of this process would have been very, very different to those to which he was used, of a nature which, I'll put it neutrally, would never have come close to being considered acceptable by the standards, for example, of a domestic kinship or special guardianship placement. And I say all those things not to criticise, but to point this out. If Lord Justice McFarlane is right, and we say of course he is, to say there's no presumption in favour of natural family, but that the fact of natural familyhood, if that's a word, is an important factor in the process of comparing different options, then the context is hugely important. And the context here is of those circumstances I've described, so a completely different alien situation for that child, and with people with whom currently there is no relationship link. The fourth general point we'd make is this. There seems to be criticism, both explicit and perhaps implicit, of this judge hurrying things, and this judge not having given proper thought or proper analysis in her judgment to what was in contemplation. If anything, we say this judge went further at every stage than perhaps she needed to. And in particular, this paragraph has been looked at already. Paragraph 73 in the judgment which you'll have a page printed 120, electronic 151 of the bundle. Starts off with the observation made by Lady Amelia Justice King that no one's saying that aunt and uncle are put forward as a realistic option at this stage. But she goes on throughout that paragraph and then throughout the judgment to consider in real detail the potential advantages to this child of that placement, the potential benefits to him, short-term, medium-term, throughout his life, even though it wasn't at that stage a realistic option. So this was anything but a quickly made, robust case management decision. Am I going to adjourn the proceedings? It was a case management decision, shall I adjourn, expressly predicated on an analysis of what this child might lose if the case weren't adjourned, but set against the potential detriments to him in the event that there was an adjournment. Which brings me to general point 5, and Milady asked Mr. Gupta, what are you saying should happen now? What could happen now? If the placement order remains stayed, where the final care order saying the court doesn't approve placement, adoptive placement or interim care order, this court isn't going to make a final decision until such stage as you've properly assessed. Then a difficult process begins to unfold. We describe this at paragraph 38 of our skeleton argument, which you will find at page 55. And this is based on the evidence given to the court, and again this passage has been agreed as accurate, and which the court accepted. If the court at first instance, either in October or now, on remission, said we're not happy with proceeding to adoption, then the case has to go back to local authority management. A lot of meetings would be needed, it said. And that goes without saying, because judicial encouragement is one thing, but to change a care plan in such a wholeheartedly significant way requires a proper and formal process to be undertaken. And then we get back, I'm quoting the social worker, into the financial aspects of the trust, which are not under social work team control, and the court will know quite how fraught the financial situation for these local authorities is. Even if funds then were agreed, the visa situation would arise. We say that there was good evidence on which the judge concluded it was 6 weeks. And that's because that was the written evidence of the social worker in her report, which was accepted by the judge. Which you'll find it's the large Roman numeral 9 on page 205 in the Bible.
Thank you.
But that was the evidence. It wasn't the judge confusing numbers 5 and 6. It was the social worker saying in her report, this is what we understand to be the situation. And it wasn't 6 weeks, it was at least 6 weeks. But if then, so authority changes its plans pursuant to all of the meetings and procedures which have to take place, then persuades the purse string holders to release funds, so visas are obtained. And you'll have noted the evidence that visas would be possibly virtually unobtainable without legal assistance, but with paid for legal assistance, then still uncertain, they would be perhaps more likely to be achieved, but still at least 6 weeks. Then the process of the family coming over here, which we say isn't a straightforward process. It's a man who works, and this isn't a criticism, it's a tribute, extremely long hours in order to provide for his family, who would have somehow to absent himself from that without jeopardising his job. It's 3 children of very disparate ages with different educational requirements. It's a house being left, and those 5 people coming to this country, so not straightforward. Then to be accommodated if the local authority will agree to pay for this. If not, there's no obvious way of this happening during the process. And the 3 weeks, which is bandied about as though that is the extent of the assessment, is just the first stage. And even that is, we've quoted it here, a best guess, at which point there would be a review. But this child, by now, almost 18 months old, will have a settled view of how life looks, how people speak and sound, and what makes him comfortable. All of a sudden, there would be a process at some stage in that of introductions, but with a view to assessing how that goes, seeing how he responds, and seeing whether a relationship leading to attachments can then be formed. It's not a straightforward process. It can't be scientifically predicted, A, as to success, but B, certainly as to the timescales likely involved in that. And then, of course, there are the other, even if the relational side of it works, the other practical issues involved. It seems unlikely, although this wasn't perhaps grappled with at stages 1 and 2 that Mr. Gupta refers to. It seems unlikely that an authority could sign off a child being placed in a house in the condition it's in. There's some reference to a payment being made for work to be done, but money in a bank, even if it is quickly transferred, doesn't equate to the building work magically having been done. So there's the practical side of what would needed to have happened. And then, as my lady has averted to, a special guardianship assessment will need to take place properly. And we've cited Mr. Kearns' working groups guidance in relation to special guardianship orders, that in particular with international placements, that is not a process to be rushed through. The pragmatic and practical issues have to be properly looked at. In order then for there to be a special guardianship order made by the court, then the necessary consent's given, simply to clear things this end, but, and it probably couldn't happen until, well, a mirror order certainly couldn't be applied for until there was an order for it to mirror. At that point then, a process starts in Pakistan, over which we have no control except if the decision was made, we could pay for it, to obtain the mirror orders.
But it's not going to be a mirror order.
Well, it's not a mirror order, no, you're quite right.
It's going to be a very different order,
brilliant
which could be challenged by the parents.
Yes.
Who do go and visit in Pakistan and to whom the aunt speaks every day.
Yes, and that's the other point that we make, that the assessment is far more than simply an assessment of this couple, the uncle and aunt, or even this family. It's an assessment of whether this British Asian child should be placed permanently and irrecoverably, from the English court's point of view, in this placement with whatever support, statutory agency support, legal underpinning is available in that country, all of which are beyond this control, but the order situation and the guarantee of stability, and ladies averted to this as well, the optimism one could have that contingency plans are properly in place are all matters of real complication. Possibly matters about which there could never be anything approaching a guarantee, but all matters we say, which mean that one can't simply say we should adopt an optimistic can-do approach. It's a 3-week assessment. Let's hope things look relatively okay by then, and then off the child trundles with the family. Because in the real world, it doesn't work like that. And in fact, maybe King, I suppose, perhaps in particular, will have experience of quite how difficult these placements abroad, especially in countries which have different systems to ours, are to effect. But for a court, an English court, for whom the welfare of the child is as a statutory principle paramount, a decision to place has to be a real decision. It has to be a decision based on a full evaluation of everything relating to that child's welfare. So again, it can't be signed off because, to coin and misuse a phrase, the fact of a family link is some sort of hyperlink. It can be signed off only at the point at which there can be proper optimism that the placement will succeed, in the knowledge that the moment the child touches down in Pakistan, he's beyond the reach of the English courts and the English statutory agencies. So, coming back then to an awful part of my point 5, which is what would have to happen now. It isn't simply a case of sending this back and pretty quickly, if things go well, we could achieve a Pakistani placement for the child. My lady asked, indicated that an update would be useful in relation to where we are with adoptive placement and twin tracking a presumptive search, even though the order's been stayed. I'm told this, and I haven't shared this before now, the social work team has held off doing a wider regional search for potential adopters due to this upcoming appeal hearing. However, the family finder did put this, by which I think is meant this child's case, suitably anonymised of course, out to Linkmaker last week. Linkmaker is a national resource, as I understand it, which assists social work teams, adoption teams, in finding potential adoptive links. So that was last week, and there have been 2 families who are very interested. And the social worker says this, that she considers that her predictions around the short timescales for permanency through adoption have been shown to be fairly accurate. So by the fact that within a week, 2 very interested families are found. In any event, the social worker was perfectly entitled to give the evidence she did give in relation to having been advised that 6 weeks to find a placement and 6 weeks to match and place was realistic. The judge was perfectly entitled to accept that, and as a cross-check, I imagine that sort of timescale, given this child's age and his characteristics, i.e. he's of a non-British heritage, but very widely prevalent in this country, and he's of a relatively young age in adoptive terms, and an attractive little boy, well and unencumbered by developmental difficulties, mean that those sort of timescales, I imagine, will resonate with the experience of the court in relation to that. So those are the 5 general points I wanted to make. We apologise that our skeleton arguments, plural, are anything but skeletal, but rather a fuller line-by-line exposition of why we disagree with the particular grounds as put. I'm very much in the court's hands as to the extent to which I can assist in going through our argument with each of the now 7 grounds as raised, whether there are any particular points that I could usefully address, or whether
Just
I'll...
give us a moment
Thank
then,
you.
Mr. Turner. Nope, we have your skeleton argument, thank you.
Thank you.
Who's going next?
The lady, I think it probably falls to me.
Now, have you anything to add then?
Well, my lady, no, I of course.
Sorry, that sounded really rude.
No, my lady is.
I do apologise. I've read your skeleton argument, of course, and as we all have, and we've heard Mr. Gupta's submission. So
Well,
I'm not
indeed.
trying to stop you. Adam.
No, my lady, I'll be succinct, and I hope to assist. There's one issue in particular that I would like to briefly address the court on.
Yes.
And it's this, in my learned friend for the local authority skeleton argument, which is at electronic page 54, bundle reference 53, and that's paragraph 33.
Just give me a moment. Paragraph 33.
Paragraph 33.
Yeah.
This is a passage within the skeleton argument that deals with one of the concerns, namely the finances and the capacity of the local authority to, even in a scenario where they were to provide financial support. My lady will have read that there were the difficulties, which is a lump sum was not appropriate because it would not be insured, and therefore we would be looking at effectively monthly payments.
And then there's all the problem of the local authorities, regulations, and the family's understandable desire for it to go through, I think it was Western Union. Wasn't it?
Indeed. My lady, it's a simple point, which
Yes.
is this, that what's relied on there is, of course, the social worker's evidence in respect of those difficulties. But the court below did have the benefit, and this is contained within the supplemental bundle, which is, of course, the advice, the two legal advice which were obtained. Indeed. And I would take the lady to paragraph 51 of the first advice, that's internal at page 16, electronic bundle page 17, where a specific question was raised on instruction, obviously, agreed instruction, to ask the question, are there any practical difficulties in respect of how financial support is payable from the UK to Pakistan?
I'm not in the right place at all here. So we're looking at,
There should be a supplemental bundle.
yes, which I have, which has got two documents.
Which has two documents. I'm referring to the first document.
Yes.
The internal page number of that document should be 16 at the bottom right-hand corner.
I have it, thank you.
And hopefully paragraph 51 should appear on that page.
I have it, thank you very much.
So, my lady, it's really a simple point, which is that the evidence also went the other way, which was that the instructed expert envisaged no difficulties. Now, I know my lady will say, well, there were difficulties. I think that the problem with that is it's not entirely clear. Of course, I didn't appear in the court below, but it's not entirely clear why there were those difficulties in terms of the local authority affecting those payments. And I know that Mr. Gupta, of course, has adopted the phrase, well, we are where we are, but the reality is that one tracks back, particularly to the 1st of August, it seemed that that was a pivotal point, and that point was particularly reached there because of the difficulties in facilitating the financial payments to allow them to travel. It's also writ large, of course, in the addendum assessment that the social worker then produced to the court at the court's invitation, which specifically highlighted that feature. So I merely raise it to
Yes,
say,
that's
of
most
course,
helpful.
that was within the canvas. Lady, in terms of our skeleton argument, my learned friends for the local authority and the children's guardian have understandably sought to assist the court by pointing the court in the direction of the paragraphs within the judgment which they say adequately deal with the relevant welfare checklist. My lady knows, of course, our submission is that I accept, of course, that the judge deals with issues such as age, characteristics, and those issues, but our submissions are predicated that when undertaking that balance, that there was a leaning towards delay in a way which didn't properly balance the positives of delay when analysing whether or not any adjournment would be purposeful. I accept that within the judgment, of course, there is reference to the benefits of this child being raised in his birth family. And therefore, it flows from that in one sense, there was that analysis. But when one looks at the four corners of the judgment, our submission is predicated that when one takes that line by line, there appears to be that balance is not evident. I would cite, for example, paragraphs 84 within the judgment, which is contained at bundle page 124, electronic page 125 in the bundle. And it's the passage that I've highlighted, which starts about halfway down there, where there's the proper and right empathy shown towards this aunt and uncle who, on any analysis, have been absolutely committed to this child. And what she says is that whilst she empathised with their position, I agree that further delay for an unknown length of time and for an uncertain outcome is quite contrary to Mohammed's needs. What it doesn't say there explicitly is why, in terms of undertaking that balance.
Well, that's threaded throughout the whole of the judgment. Sorry, that's...
Well,
I mean, I've looked carefully at your additional grounds of appeal, which because this is such an important matter for this child,
yes,
I was happily gave permission.
Of course.
But I have then conducted the exercise of going through the judgment with the welfare checklist next to me. And I'm not going to do it now, but I have put next to all the paragraphs which relate to each of the welfare checklists, both the Children Act and the Adoption Act. And I'm sorry, I just don't see how you say that the judge didn't take into account all the matters or didn't properly take into account the issues in the welfare checklist.
My lady, I put it in a slightly different way. It's not that those factors weren't necessarily considered. It's that there is an absence of a fair balance. So if one looks, for example, above that paragraph, at paragraph 81.
Well, perhaps better look at 79 if you're saying that it didn't consider the delay.
Yes, I accept what it says at 79, but if one moves to look at 81, it says it is, however, inevitable that an adjournment would need to be for at least 3 to 4 months. And I know that my lady has dealt with this extensively already this morning. We say that there was an element of speculation. I accept that the court has already dealt with that to an extent in terms of the timescale that was given by the social worker. And as a result of that speculation, when undertaking that balancing exercise, there is a paucity contained within those paragraphs of a balance on the positive side for purposeful delay. That there was not an examination of what steps in reality could be taken. And in terms of the submissions that have been made in respect of forcing a local authority's hand by robust judicial indication, of course, it may well have been the case that the judge could have determined or made a determination that it would be in the welfare interest of this child to receive support from the local authority, and then invite, of course, the local authority to reflect on that determination and the process that would then follow from that. But, my lady, as I said from the outset, I think those submissions are threaded throughout my document. There is nothing else that I would wish to add.
Just give me a moment while I just look at your point I wanted to raise in discussion. I'll just see if I've marked it up. No, I don't think there was. I think you've dealt with his matters. Anything else? Anything else? Thank you very much. That's most helpful. Now, what about the father? I won't be rude to you and say, do you want to have it?
Yes, I'll be brief.
No, take your time. We've got plenty of time.
There are just 4 matters that I wish to raise. But firstly, I adopt the submissions made on behalf of the appellants and the mother in respect of the
Yes.
substantive appeal. And so far as ground one is concerned, the first issue that I wanted to raise, having heard the submissions and the exchanges this morning, firstly concerns the reference to immigration advice that was received by the social worker and then relayed in evidence to the court. And that is where the court accepts a period of 6 weeks for the visa application process to complete. My lady, it's right to say that there was no joint instruction of an immigration expert within this country. There was no transparency in the sense that no advice was circulated to the parties or indeed the court, and therefore there is a risk that the social worker, the judge, was in turn relying on the social worker's interpretation of advice that had been received. There was no clear identity as to the questions that had been put to the immigration expert.
Was this raised with the judge?
It wasn't. I accept that it wasn't raised with the judge.
Is it a ground of appeal?
Your Honour, my lady, it's right to say that
It's quite a serious allegation that you're now making for the first time, as I understand it.
well, I say it's relevant to the issue of the weight that the judge at first instance was placing on the time frame of the visas. Had there been transparency about that, that would have clearly have assisted. I'm not going as far, and I make it clear, my lady, I'm not going as far as to say the social worker was misguided or misleading the court, but there could well have been other information.
Was the social worker cross-examined?
She was cross-examined.
She cross-examined on this topic?
She was cross-examined on this topic. She was cross-examined as to whether or not, in addition to the advice being received, whether the aunt and uncle had received immigration advice and the local authority had supported, whether they had supported the aunt and uncle to receive such independent immigration advice to assist them in the visa application process. But I make it clear, I don't go as far as to suggest that the social worker was misleading the court by giving the time frame of 6 weeks. I accept and I assist the court by the reference within the addendum assessment to the social worker that refers to receiving legal advice from Batley Law Centre. That's referred to and set out at the beginning of the addendum assessment. But one difficulty is that it would be, of course, usual for the entirety of that advice to be before the court and the parties. It was advice that was sought from the local authority, but not on joint instruction. So I raise that because I say that there is potentially important questions that could have been put, that the court could have been assisted by to the immigration expert in relation to what the local authority could do to assist further in ensuring the aunt and uncle come to the UK in a timely manner. Now, I echo the submissions that Mr. Gupta made in relation to how the court could use recitals in an effective way to persuade, although not dictate, to the Home Office authorities to allow and encourage visas to be granted. But it is one area where it's heavily emphasised by those who resist the appeal that there was very clear evidence in relation to the difficulties concerning visas, the duration of the process for that, and I submit that there could still have been further information that was sought to assist the aunt and uncle, and that information could have in turn assisted the judge dealing with this issue when considering whether in fact there were uncertainties or whether in fact there were issues that could be resolved by the input of an immigration expert.
Can I ask you a question, please, Ms. Sheikh?
Yes, of course.
Does it follow from the answer you gave to my Lady Justice King's question that the social worker was not cross-examined about any of these matters?
No, my lady. The social worker was cross-examined about the immigration expert and whether the advice had been provided to others. It's right to say she wasn't specifically cross-examined about the accuracy of the information about 6
So
weeks.
was she pressed to provide the advice?
My lady, I accept that she wasn't pressed to provide the advice.
Okay. Thank you.
I move to my second point then, my lady, that relates,
I'm very sorry to interrupt. So,
of course,
so
my lord.
what's the argument? The judge should have asked for this.
No, my lord, I say that if relying on the information that the social worker
Yeah.
had obtained from an immigration expert, that should have been provided to the court to assist the court to ensure that there weren't other matters in that advice, or there should have been joint instruction to ensure that there was clarity as to how the aunt and uncle could come to the UK and whether there could be support or, assistance or recitals or evidence that could be submitted by the local authority to assist that process.
So is the submission that although this wasn't raised with the social worker when she was giving evidence, the judge should somehow have intuited that this might be an issue and not have relied on the advice? I'm just not understanding the submission at the moment, I'm afraid. I think it's my fault.
My lady, no, perhaps I'm being unclear. It's right to say the social worker gave evidence about the issues in relation to visas and the time frame for those visas. It's correct to say that there is reference to that in her addendum assessment. But what was not before the court was the immigration advice itself.
I've gathered that, but what are you saying the judge, how did the judge get this wrong? It doesn't sound as though this was ventilated at the hearing.
Well, I submit that it ought to have been provided to the court at
But there was
first
an
instance.
opportunity when, because we had Mr. Khan and then we had an addendum from Mr. Khan. We had CFAB and then an addendum from CFAB. I mean, an application could have been made for immigration advice on joint instructions. No such application was ever made, and then the social worker wasn't challenged. How can it possibly the judge be criticised now
But there is
for
some,
not
forgive me,
for accepting the effectively the unchallenged evidence?
but the judge didn't have the full picture, as it were, in relation to what that expert advice from the immigration professional set out. And that would have assisted the court, because within that advice,
Well, look, that may all be right, but no application was made for it by anyone.
I accept that. Perhaps I can move on then to my second point, which is in response to the local authorities' skeleton argument at page 53, paragraph 31.
Thank you.
It's in response to the ground that relates to, again, the proposed plan and further assessment of aunt and uncle in court with uncertainties. There is evidence, there is reference to the state of banking systems in Pakistan, and the court have already heard submissions in reference to the financial circumstances and what the local authority appear to assert are financial difficulties with the banking systems and the systems in another jurisdiction. The evidence that was before the court from the social worker in relation to the financial sector in Pakistan appears at page 204 of the addendum assessment.
Thank you.
I'm looking at the
Roman 4.
Roman 3, in fact,
Roman
my lady. Where within the assessment, the social worker states that there are differences in banking and financial regulation between Pakistan and the United Kingdom. In comparison to many developed countries, the financial sector in general is underdeveloped. Well, there is a reference there.
Mhm.
The social worker, of course, is not in a position to give expert evidence about the banking systems in Pakistan, and it would be wrong for the court to have factored that in as an uncertainty to suggest that banking systems and financial institutions abroad are in some way inferior or defective without having a solid evidence-based conclusion or documents before the court. And so I invite the court to note that if it is said that the judge at first instance relied on one of the aspects of why she concludes there are uncertainties, or the plan with the aunt and uncle is fraught with uncertainties, is based on what is said by the social worker in her addendum assessment about banking institutions and financial systems, that clearly was an error, because the social worker is not in a position to give evidence in relation to those matters. So I say that that was an approach that was adopted by the judge that was wrong when
Are you saying
factoring-
then the judge couldn't take into account Roman 4, 5 and 6?
Roman 4, my lady,
Which tells us actually what was happening on the ground.
but it doesn't provide, the social worker is not in a position to provide expert evidence about
And that's
financial
why I'm looking at the
transactions.
actual evidence she gave of what was happening on the ground. She's not trying to give expert there.
She's giving factual evidence about actual difficulties that have occurred in this case. Is she not in a position to do that?
She's making reference to Western Union
But
transfers.
that's what the aunt and the uncle say exactly that. And they say they can't have a lump sum because you can only have 100 and whatever. There's only insurance for it's £114, somewhere around that.
1,400
£1,000.
pounds.
1,400. 114. Anyway, there we are. A modest amount, and that the family would prefer Western Union. So why can't the judge take into account?
Well, forgive me, my lady, I say that to take anecdotal accounts of what is happening does not necessarily mean
It's evidence. It's not anecdote. What actually happened on the ground when they tried to send the money, and the family saying we can't take a lump sum because giving a reason. That's not anecdote.
that the social worker ought to, my submission, and this ought to have been before the court, for the judge to have been able to take this into account, she ought to have made those inquiries with banking institutions that are
We should
based.
have had expert evidence from the banking experts as well.
I'm not suggesting expert evidence from a bank, but to say, firstly, that the systems are underdeveloped.
Well, forget
is-
that. Let's look what was happening on the ground.
That is one example, and there may have been other ways to remedy the anxieties around providing funds to the aunt and uncle.
So
They are
was,
lay people.
was the social worker cross-examined about this aspect of her report?
She was, yes. She
Or she asked?
was asked about her knowledge of the banking systems.
Yeah.
Forgive me, I'll have to bring up my note. How she obtained that information that's set out in 3 and 4. And
Was the Fitch document in the bundle?
it isn't, no.
Was it? Sorry, was it?
No, my lady, it wasn't. Lady, I'm just trying to find the note of the evidence.
Well, but what I'd like to get at is whether she was cross-examined about the factual matters that she's reported in this bit of her report.
When she was referring to Western Union as a mechanism,
Yeah,
she was cross-examined about that,
right.
and she gave evidence that this was information that she had obtained from the mother. So it wasn't from the aunt and uncle, from recollection. I don't have the exact verbatim note, but it was information from the mother. So where it is said that there are these uncertainties and anxieties around financial systems, transferring funds, I accept that there have been some difficulties and of course some delays as a consequence of the local authorities' actions in relation to transferring money to this aunt and uncle. But what evidence the judge did not have before her, and what would have assisted her, is if the social worker had provided, made inquiries with banks that are both based here and in Pakistan to see how those unknowns or areas of vulnerability could be remedied. Now that evidence wasn't before.
Was that
the
submission
judge.
made to the judge?
My lady, I can't recall exactly whether that was specifically made, but it was certainly the issue of the social workers' knowledge of the financial systems was an area of topic that was dealt with in cross-examination.
Right. So the judge heard the social worker cross-examined about this and accepted the evidence that she accepted. Why isn't that a decision for the judge?
Well, it's relied upon by the local authority. Certainly the financial and banking systems being different is relied upon by the local authority to challenge this appeal. And so I make my submissions in response to that. And what I say is that the judge ought to have been cautious in placing weight on that particular aspect of the social worker's evidence, because she wasn't in a position to give an informed view. Yes, there was the example of the aunt and uncle having difficulties obtaining funds, but that did not lead to, and ought not to have led the judge to the conclusion that a potential future placement with the aunt and uncle and a potential option of the aunt and uncle ought to be discounted because of difficulties she perceived.
You better
around
take us in the
financial
judgment
systems.
where the judge made that finding. But because of financial difficulties, there shouldn't be a further assessment.
My lady, except that wasn't referred to explicitly by the learned judge, but I raise it because it is said when defending the learned judge's decision that there were uncertainties, and the potential placement with the aunt and uncle was fraught with uncertainties. So I make my submission in response to that. The court has also identified that there were uncertainties in respect and difficulties in respect of the legal position in Pakistan, and if I may address the court
Are
on
we
that.
moving on to number 3?
Yes, grateful.
So if I look through this judgment, which I'm surprised to learn I've already done, I won't find any reference to the judge saying, well, the state of financial institutions in Pakistan and or difficulties in getting money to these particular people is a significant consideration in my decision.
No, but the judge does make reference to the uncertainties, and when looking at the evidence of the social worker, and it said that the social worker's evidence was accepted by the judge in its entirety. The evidence before the court also included this evidence from the social worker about financial institutions.
The judge doesn't mention financial institutions.
I accept that she doesn't mention
No, all
financial
right.
institutions.
Right, legal. So this is Mr. Khan's evidence, is it? We're moving on to now.
Yes, my lady. My lady, forgive me if you may just. In the court's earlier exchange, there was reference to the legal opinion of Mr. Khan. There are, of course, two reports, and the legal expert indicating placement within 6 months. That's paragraph 31, page 9. The court also has referred to the position in respect of a guardianship order being obtained from the family court in Pakistan before a placement is invoked. My lady, in response to that, I simply draw the court's attention to the opinion of Mr. Khan, where he states ideally it should be obtained. That's at paragraph 37, page 10 of the opinion.
Yes.
And I say that when looking at this in the context of whether or not this potential option of aunt and uncle was fraught with uncertainties, it would be wrong for the court to have approached this or to suggest that there would be a delay, a significant delay of placing the child with the aunt and uncle abroad as a consequence of taking that sentence as being a mandatory requirement. So it's
Now,
not.
Are you really saying that the judge, having got that expert evidence and the addendum to the expert evidence, and that being the recommendation of the expert in Pakistani law and process and procedure, given that Pakistan, notwithstanding the Pakistan protocol, that the judge should have ignored that recommendation, and notwithstanding this isn't a Hague Convention country, simply placed the children there with these relative strangers
Well, my lady,
before having a special guardianship order?
my lady, there were other legal options that could have been invoked. There could have been, following an assessment in the UK, a placement under Schedule 2, paragraph 19 of the Children Act. Of course, that would require the approval of the court, but there were other legal mechanisms to effect
And were these all put to the judge?
a quicker. From recollection, I believe that there was reference to a placement abroad, but I'd have to check my note in respect of that. But for the court to simply take from Mr. Khan's opinion that he is suggesting that this is a mandatory, when there are other options for the court in these circumstances, the courts, and my next point related to the assessment and transition plan that the court's been referred to on a number of occasions. Now, I appreciate that's not before the court, but there is a reference in the chronology at page 85, which sets out the terms of the assessment and transition plan. I note that the court earlier...
Sorry, page 85 of what?
85 of the main bundle, my lady. I note that the court had earlier observed that it was unlikely that a 3-week period would have included both the assessment and transition plan. But that was certainly the position of the local authority on the 3rd of June.
What, that in
when they
3 weeks the
presented-
children would have moved full time to the care of the aunt and uncle? That's not what I understood from the evidence.
It was with a view to them being placed,
No, it was with increasing contact.
and it was for a period of 3 weeks where
No, the 3 weeks, after the 3 weeks, then we were told, I think
if I
the
take,
doctor told me.
my lady, if I take the,
I'm looking over his shoulder to Miss Shield.
I think I used the word transition, Your Ladyship.
yes, my lady, the summary at 84 is correct in relation to what was set out in the assessment and transition plan. So it was both.
Sorry, what paragraph on page 84?
My lady, page 84 should be the chronology from mine.
It says chronology in support of the application. My 84, is that your 84?
Sorry, are you referring us to paragraph 84 of the judgment? I'm a bit confused about what you're asking us to look at. It's my fault.
No, apologies, it's 85 of the chronology. So this is the document that's the chronology in support of the application, and it's Roman numeral X, where it refers to the local authority filed and served a document
thank
headed
you.
Proposed Assessment and Transition Planning on the 3rd of June. That transition plan set out clearly that the aunt and uncle would be in the UK and stay for a period of 3 weeks. And then further at Roman numeral 8,
Yeah, then after the 3 week period.
with a view to aunt and uncle beginning to provide direct care
Yeah.
for the child independently and for increasing periods.
Yeah, that's what I thought.
The suggestion that it was going to be a longer period before the aunt and uncle have significant period, are responsible for significant periods of care of the child, and that would add to even further delay. I query the judge's approach in being dismissive of imposing a shorter and robust time frame that the appellants invite this court to consider. This was a local authority who'd prepared this assessment and transition plan. This was a local authority who had previously given assurances, again set out in the chronology, but also in the judgment of the judge, on a number of occasions, that they would fund the travel and stay to the UK. 10th of May, the social worker provides a statement to that effect. That's referred to in the judgment at paragraph 107. And again, the reference to a commitment to place the child with the aunt and uncle was confirmed by the local authority both on the 24th of June. The chronology sets that out at page 86, and on the 1st of August, the commitment to again fund a placement in Pakistan. So I say against that background, when it's suggested
Sorry, commitment to the placement.
commitment to fund a placement in Pakistan, that's of course subject to a positive assessment taking place in the UK. But against that background, the judge was wrong to dismiss the option of the aunt and uncle and a further assessment of them, and that that option was fraught with difficulties. Given that this is a local authority that had previously being committed to this approach. When it is suggested that, of course, there would need to be time for the local authority to consider any rejection of their plan of adoption by the court, if that was the court's decision, if that had been the court's decision. A less pessimistic view could well have been taken by the judge in my submission on the basis that the local authority had only a few months earlier, prior to the final hearing, made clear their commitment to explore the aunt and uncle. And I say it has to be considered in that context. So when looking at the weight that the learned judge places on uncertainties, it has to be considered in that context. And I echo the submissions of my learned friend, Mr. Gupta, that these were matters that could be addressed and could properly have been managed. My lady, forgive me, reviewing my notes, there isn't anything else that I wanted to raise at this stage.
So you've incorporated your number 4 as you've
I
gone
have.
along. That's fine. Any other questions? Any other questions? No, thank you very much
Thank
indeed. Yes, the Guardian.
My lady, clearly 2 very lengthy skeleton arguments have been filed on behalf of the Guardian. With the court's leave, I would simply seek to distill the Guardian's case on each of the grounds.
Thank you.
I'd hope to be no more than 10 minutes. And my lady, in respect of ground 1, the challenge to the conclusion that any placement with the aunt and uncle was fraught with uncertainty. Of course, the important point to make is that this was a factual finding of a first instance judge who had carefully considered the evidence and the witness evidence over the course of 5 days. And the appellant in this case must, of course, face an uphill struggle in dislodging such a factual finding. That factual finding, we submit, must be right. The uncertainties in the case must be considered cumulatively. It was uncertain whether the Home Office would grant visas. It was uncertain whether the kind of significant financing required to make this placement work could be procured. It was uncertain as to whether the real issues identified in Pakistan in terms of schooling, in terms of lack of statutory oversight, in terms of home conditions, could be resolved to the satisfaction of the UK authorities and court. It was uncertain whether a guardianship order could be procured in Pakistan. It was uncertain whether such orders would provide legal security to the child, given the risks posed by the parents and their own attachment to the Pakistani area. It was uncertain as to whether the uncle could play a part in the placement or would be required by circumstances to return to Saudi Arabia. It was uncertain if any meaningful contingency plan could be put in place. All of these matters must be considered cumulatively. There were uncertainties across the board on multiple important welfare issues. This experienced judge was right to find that the proposal of placement with aunt and uncle was fraught with uncertainty, and the appeal against that factual finding, in my respectful submission, is without merit. I turn to ground 2, which is of course a challenge to the judge's finding that an assessment and placement process would take between 6 and 12 months. Again, a factual finding, again, appropriate deference owed to the decision of a first instance judge who heard the evidence over 5 days and gave the aunt and uncle every opportunity to develop and put their case. My lady, I simply say this: one has to consider the cumulative, complex steps that would need to be taken to achieve a placement in Pakistan in this case. Firstly, the court's judgment would have to be considered by local authority management and resource panels as to whether finance would be provided, as to whether the care plan would be changed. That takes time, particularly at a point in time when local authorities are struggling in terms of resources. Applications would have to be made to the Home Office for visas. Whatever judicial encouragement was offered, that is going to take time. Practical arrangements would have to be made for the aunt, the uncle, their 3 children to transplant themselves to the United Kingdom, to find accommodation, to resolve working issues, schooling issues, practical issues. That takes time. Further assessment was required, not just about the issue of money, but about the outstanding issues in Pakistan, about contingency planning, about the child actually meeting the proposed family carers and the reaction of the child to the family carers, the quality of contact, the hands-on interactions. This was a substantive piece of assessment work that was going to take time. Any reports would need to be written up. Responses would have to be provided. A court timetable set. A further hearing listed. A special guardianship report prepared. There would have to be applications for orders in Pakistan. Those orders would have to be secured, and the UK court would have to have confidence that they secured the child's position in Pakistan. All of these complex, difficult steps would need to be taken to achieve a placement in Pakistan. In those circumstances, the judge's finding that it would take 6 to 12 months to realise any placement simply must be right. And it's certainly not a factual finding that can be properly challenged on appeal in circumstances where this experienced judge carefully considered the relevant evidence and witness testimonies. I turn to ground 3, challenging the judge's suggestion that there was a real possibility that an effort to place with aunt and uncle could fail, either due to a negative assessment or practical difficulties. That finding, in my respectful submission, was an inevitable consequence of all the uncertainties and unknowns in the case. If the financial means could not be provided for this placement, it, on the evidence of CFAB, would be non-viable. If visas could not be procured, the placement would be non-viable. If the issues in Pakistan, in terms of schooling and home conditions and oversight, could not be resolved, the placement would become non-viable. If the child responded poorly to the carers or their issues in contact, it may be that the placement becomes non-viable. Issues could have come out of the detailed special guardianship assessment process, rendering the case and placement non-viable. If the Pakistani courts had refused to grant a guardianship order, the placement could become non-viable. If such orders could not provide legal security to the child, the placement would become non-viable. All of these uncertainties, all of these roadblocks and stumbling blocks properly justified the conclusion that there was a real possibility of a negative assessment, a real possibility of an ineffective outcome. The judge was duty-bound, in my respectful submission, to confront that reality. Optimism is all well and good. A can-do attitude is all well and good. But the family court must adopt a hard-headed and evidence-led approach. There were stumbling blocks, there were significant uncertainties, and in my respectful submission, Judge Astbury's factual findings on that point are unassailable. I turn to the issue of ground 4, which challenges the state of the evidence in terms of adoption and adoption timescales. The social worker gave clear and unchallenged evidence on this point. She was clear that she had appropriately liaised with one adoption. She advised that she expected 6 weeks for a match, 6 weeks for a placement. Good prospects of success within a good period of time due to the child's age, good health and developmental stage. That evidence was unchallenged. Nobody applied for or requested direct evidence from one adoption, and it was evidence that was accepted by the court within its factual findings and within its clear judgment. this judge, in my respectful submission, was entirely right to conclude that the timescales in respect of adoption were faster and more certain for this little boy, given the evidence before the court. And in the context of the case being in week 62, that of course needed to be an important consideration for the court. I turn then to ground 5, which raises the possibility of the court imposing a focused and robust timetable. My lady, I make these points. Firstly, this was not an issue of judicial will. There were many, many matters that were outside the control of the learned judge. The learned judge had no power to compel decision making by local authority resource panels, by the Home Office, in terms of practicalities on the ground in Pakistan, no ability to control the decisions of the courts of Pakistan. My lady, there were matters that were wholly outside of the court's control. And in those circumstances, those uncertainties were a proper matter, leading the court to the conclusion in part that further assessment was not in this child's interest. The second observation I make is the skeleton for the appellant talks about a focused timetable, a robust timetable, as if a period of some weeks would put these matters right. Well, that does not accord with the court's findings, does not accord with the complexity of this case, and it does not confront the reality of this case and the delay the child here faced in the event of further orders for assessment. The final point I make on ground 5 is this. Ground 5 says that the court could have imposed such a further timetable. Of course, the question is not whether the court could impose such a timetable. The question is whether the court should impose such a further timetable. And in week 62, where this child was 15 months of age and about to enter a key development stage, and every day of additional delay on the evidence before the court was causing further harm to this little boy, this judge was right to conclude that enough was enough and that permanence and a forever home needed to be achieved. The guardian supports that judgment. She is of the view that it was the right decision for the child in this case, and it is certainly, in our respectful submission, a judgment that was properly open to the court on the basis of the evidence and materials before Her Honour Judge Astbury. I then deal very briefly with the additional grounds filed on behalf of the mother. In terms of additional ground 1, which concerns the welfare checklist and its consideration, my lady, I simply say this. Every single element of the enhanced checklist is addressed. All the positives of the aunt and uncle's case are addressed. All the risks of adoption are addressed. It is a proper, balanced, scrupulously fair judgment delivered by an experienced Children Act judge. I say no more on that ground. I turn to additional ground 2, which concerns the family not being given the opportunity to put further welfare evidence before the court in terms of further assessment. I simply say this. There is no right to put further information and evidence before the court. The court has a duty to confine the evidence to that which is necessary. It has a duty to confine the delay to that which is necessary. There is almost always more information that can be sought in a public law case. There are almost always more inquiries that can be made regarding family and family options. But it is a key prerogative of a first instance family judge to assess when enough is enough, when the delay considerations in the case must prevail. Judge Astbury formed a clear view that that point was reached in this case in week 62. That was a point of view supported by the social worker, supported by the guardian, and in our respectful submission, supported by the clear evidence before the court in this case. My lady, that in essence is the guardian's position on each of the grounds. She encourages and asks that the court reject the appeal and allow this little boy's permanence plan to progress without further delay. Is there anything further I can assist with on behalf of the child?
Not for me, thank you. Anything else? Anything else? No, thank you. Mr. Gupta,
Your
anything in reply?
Well, Lord, I shall be less than 6 minutes in reply.
Yes, well, given that you've had Three shots so far. You
Indeed.
and the mother and the father.
Indeed, yes. Simply this, in response to my own friend, on behalf of the local authority. Yes, he says it's not a scientific process when it comes to placing children, or this particular child potentially with his aunt and uncle, but I respect that that's equal for the adoptive process. There is potentially more certainty, one could argue, when it comes to adoptive carers, because they've been through the procedure with regards to being chosen and being assessed, etc., and giving approval. But in any event, again, that is not a scientific process either. Just a side swipe at my learned friend. It's a shame that we were given this new information about link maker, etc., in court. I'd ask the court to disregard that, please.
Well, I won't disregard it, but you feel free to take him to task when you get
Yes,
out.
I will do. And
I'm sure he will apologise appropriately.
sure. And with regards to those submissions on behalf of the child,
Yes.
what can we say? Permission was granted. We do have a realistic prospect of success in this appeal. And I'd ask the court to continue as it started, which is my clients are not to be criticised for this process that we are where we are. They've tried their utmost with regards to the assessment and getting through to the final part of the assessment. And that matters are not as stark in our submission as those put forward on behalf of the Guardian. Everything that could be done should be done within, we accept entirely, the procedures that we have in this court. But for all the reasons that we've said already, and I've said already, endorsed by my own friends on behalf of two of the respondents, or two of the four respondents, that this should be, the appeal should be allowed, and the process in the court below should be allowed to continue. Can I assist you, if I have been of any assistance, any further?
You've been of considerable assistance, as always, Mr. Gupta.
Thank you very much.
We're just going to rise for a few minutes. I'm sorry, you might have to just pause for your sandwich for a few minutes.
If you feel uncomfortable during this hearing at all, I was uncomfortable.
Did the judge say to Mr. Gupta to pause for your sandwich? Without knowing it, he dines at the Waldorf every lunchtime without fail.
It's absolutely freezing.
Right, I figured out a way of sorting these lecterns out finally. Look, all the sweets underneath.
Very few provinces.
My last hearing of James Tyler,
Make a difference.
bless him,
Yeah.
he had this lectern and he said, I had a carpenter build it. I said, yeah, I have been building it during your submissions.
So that you know the tape's still running.
Sorry?
The tape is still running.
And there's such a kind and fair tribunal.
So, Harvey, and I've sent those documents onward. So,
Thank you.
I've got a standard acknowledgement.
So it's been acknowledged.
Yeah, just like the standard email back. I haven't had a response from a real person.
What's this, eh?
The orders, the
Yeah.
judgment.
We copied it in, everyone in, yeah?
Did we send the orders directly to you, the lady? I do it to you.
No, you sent it to the judge's clerk,
to the
or to the civil police office.
Yeah, that's where it's been
Send
sent.
it to the listing office.
That's fine, that's where we've been sending documents.
Yeah, okay. If they don't, they'll ask, one of their clerks will ask me. But if you sent me, have you copied me?
You were
in?
copied in,
Right, well, I can
yes.
forward it on.
I think it was in this court that I had to do that tag team act with.
Yeah, it's against court.
You know, I wouldn't normally encourage that, but it would be your Cayman case, or is it PCI?
Yeah.
If you think that a team is indicated.
It's definitely an under.
happy to stand in.
I just don't think we've tapped into that at all. It's a closed shop for QEB and the rest of the game. Really annoying. They do all the children work, and you think,
This is Cayman, BVI.
this was BVI, but Cayman as well.
Yeah, I
you know.
agree.
And you think, come on, guys, you know. So it used to be Cosworth before, and then it was Moston. Speaking to one solicitor, as it came to case, one solicitor said there was some volcano or something,
Well, I've
which meant that he had to leave the Cayman Islands for a
Wow.
year.
Just
And
about to go.
he went and lived with Moston. But yeah, so that's kind of marketing on a different level.
For a year. Dear God.
One of his houses or something.
Isn't it? You know,
The manager has government didn't.
Mr. Gupta,
Yes.
we're going to dismiss the appeal, but we will give reasons to follow. You'll understand that the reason that we're taking that slightly unusual course is twofold. It's partly because your lay clients are actually listening on the live stream,
Yes.
and so they have an opportunity to actually know the outcome and not have to wait probably several weeks until they have the outcome. But more importantly, it's critically important now that things move on for M, and if there are indeed two families that have expressed an interest,
Yes.
it may or may not be that they come to anything, but certainly given his age, we take the view that it's critically important that, having listened very carefully to all the submissions that were made and all the anxieties expressed by both the parents and on behalf of the aunt and uncle, that the decisions are made and matters move forward for this.
Well, thank you, Ladyship, and we'll draft up an order accordingly, and I assume it will have provisions for public funding, taxation,
Of
etc.
course, of course. I don't know, is anyone pro bono in this matter that I need to
Yes, I
thank?
am.
Thank you very much indeed. I'm very grateful.
Yes, and my instructions has mentioned translation, so we'll have to ask for dispensation for translation or something like that. Or things like that.
Whatever's necessary. Obviously it's very important that the
Yes.
aunt and uncle are able to read them or have read them in due course.
Judgment,
I've
yes.
always said, just when you're drafting the order, just to be on the safe side, could you make sure that it expressly says that placement, matching and placement can proceed, notwithstanding that the final judgment has not been,
Yes,
the reasons
of
have not
course.
been handed down. We're making the order today.
Yes, we'll circulate the order very soon. I'm sure it'll be agreed.
Very thank you very much, and may I thank the aunt and uncle on behalf of the court, because they must, as I'm sure they do from the advice given by your instructing solicitor and yourself, there is absolutely no criticism of them at all. They're absolutely admirable on any level. To think that they were prepared to disrupt their whole lives and move over to this country just for a few weeks in order to show their commitment to offering a home for M is admirable, and they only have our praise and thanks.
Thank you for those words.
All those in favour?